Merry Christmas, baby. Reindeer's coming out to play. Santa Claus is packing the presents, making sure you've been behaving okay. Merry Christmas, honey. Yeah. The snowman's dusting off his hat, on the show for everybody. You give them a smile that lasts another year. There's something that happens when sleigh bells are ringing, when December ends, when the children are singing, yeah. It's Merry Christmas, baby. Merry Christmas, baby. The snow is laying 2 feet deep. Now wish upon a falling star, so all your secret dreams can come true. There's something that happens when sleigh bells are ringing, when December ends, when the children are singing, yeah. It's Merry Christmas, baby. Ooh, yeah. There's room at the table for big and for small. All the fire is popping, the chestnuts are cracking, yeah. Merry Christmas, baby. There's something that happens when something's that happens when December ends, when December ends, yeah, yeah. Oh, it's Merry Christmas, baby. Merry Christmas, baby. It's Merry Christmas, Merry Christmas. It's Merry Christmas, baby. Yeah. It's Merry Christmas, baby.
Well, hey, y'all, how's it going? How are we? We meet again. Yes, we do, Ren Dad. A lot of you guys in here tonight. Good to see everybody. The best Mama Bear, where you been? I haven't seen you in a while. You been busy? Having a life? Hello, Miss JPC. Serenity, you didn't miss nothing, girl. Bruiser says hi. Laura's been a member for 2 months. Woo! Go, Laura. Thank you, honey. The intro is too long. Sean, I like my music now, Sean. Do you know why I do that, Sean? Because it gives everybody time to get on, number one, because I'm really bad at scheduling my lives. And number two, I enjoy the music, and so does a lot of people enjoy the music. And I've gotten on I've become really good about going back and starting to hang on, let me get Bruiser. He's trying to get up. I've been time stamping. Okay. I've been time stamping when them songs stop. So when y'all go back to replay it, you won't have to listen to it if you don't want to. See, Patty thinks I pick good music. Sean. I'm going to put you in the other courtroom, Sean. Hey, Bluesy. All right, guys. Well, I know I've missed somebody. Hello, Miss Kimmy. I know I've missed a lot of you guys. Bob Kitten. I love music, period. Me too, Serenity. I just do. I love music. I'm a music person. So today we're doing a twofer again. It's like Rocky Horror Picture Show, double feature picture show. I didn't say it's too long. I love the music. I didn't say it's too long. I thought that's what you said, Sean. No, Sean. It was a different Sean. There's two Seans in here right now. Y'all need to get your Sean straight. All right, guys, let's get to this. We're going to start off with Halderson, and we're still trying to. There's more evidence, you guys. More evidence. This kid is so just dumb, or I don't know. Maybe he's just lazy. I don't know which one it is. I'm going to be honest. I do not know.
Okay. Folks, given the nature of the next testimony and the length of time, we've been here an hour, but it's also been an hour that was intense. So let's go ahead and take a break at this point for convenience, and we'll come back in 10 minutes. And
this is where we left off yesterday, so it'll go back right into starting again. They hear you, Bruiser. They all hear you.
Witness, please.
I call Denise Jones from the Wisconsin State Crime Lab.
Hey, Mo. I've done some stuff on Dawn, but I don't know her criminal culpability. No, I mean, no. I'm sorry, I understand now. You're good.
Good afternoon. I've had a discussion with every witness about whether they are willing to or believe they can safely and responsibly testify without a mask, but I've not ordered anyone to do so. Is it your preference to remain masked at this time, or could you testify without?
I'd prefer to have it on.
Very good. Then if you can pull the microphone really close, because it does have a tendency to muffle, and we'll make sure that we can hear you and that the jury can hear you. Thank you. Go ahead.
Good afternoon. Could you please state and spell your name for the court?
Denise Jones, DENISEJONES.
And what do you do for a living?
I'm a senior forensic scientist in the DNA analysis unit at the Wisconsin State Crime Laboratory in Madison.
How long have you been employed by the Wisconsin State Crime Lab?
14 and a half years.
What are your duties and responsibilities there?
I examine evidence for the presence of biological stains, such as blood, semen, and saliva. I extract DNA from those stains and make comparisons to known individuals. I write reports on my findings, and I testify in court if necessary.
Could you tell us about your educational background?
I received my Bachelor's of Science in Biology from the University of Wisconsin, Stevens Point in 2001, and I received my Master's of Science in Bacteriology from the University of Wisconsin-Madison in 2004.
Have you received any specialized training in the field of serology, DNA, statistics?
Training on statistics and star mix for about 2 months prior.
Thank you for your membership gifts, Miss JPC. Let me know who got them.
Certified as an expert in court?
Yes, this is my 48th time.
Can you tell us, we'll talk a little bit about the laboratory, the Wisconsin State Crime Laboratory. Is that an accredited lab?
Yes, it is.
And what does that mean?
It means we meet accurate and reliable testing.
Sure. Do you and your lab undergo any sort of proficiency testing?
Yes, I am required to undergo 2 proficiency tests a year.
Okay. What do those consist of?
It's samples that we would see in casework and to see if we can accurately and reliably do DNA analysis.
Thank you,
DNA?
Mark.
DNA stands for deoxyribonucleic acid. It's the DNA we inherit from our parents. We inherit 50% from our fathers and 50% from our mothers. And it codes for all structure and function in our body. And DNA is found in every cell in the body except for red blood cells. So it's found in skin cells, white blood cells, and sperm cells.
How is DNA used in forensic science?
So most of our DNA is similar person to person, but there are specific areas that distinguish us from others. And it's those areas that we look at in DNA in forensics. Everyone will have differences except identical siblings. We look at 23 of these genetic markers and one that's specific for gender.
You said everyone will have different DNA other than identical siblings.
That's correct.
Lisa got one.
Can you tell us how DNA testing is conducted at the laboratory?
Can you be a little bit more specific?
Sure. What's the steps for conducting DNA testing when you're at the crime lab?
So we have multiple steps in the DNA analysis process. We have what's called extraction, which we are extracting the DNA from the sample or opening up the cell to get the DNA. We have quantitation, which allows us to determine how much DNA is in a sample, which will allow us to know whether or not we need to go on for further testing. And currently our kits, we can determine how much human DNA is present, how much male DNA is present, and whether or not we can detect degradation or inhibition in the sample.
Are these methods of testing and typing generally accepted by the scientific community?
Yes.
And do the majority of forensic scientists use these methods that you use?
Yes.
Are there multiple levels of review conducted to ensure that the correct procedures are followed in each case?
Yes, we have what's called technical review, which another qualified analyst also reviews the case file and report and looks to see that I followed our procedure manual correctly for interpretation, statistics, and notes.
Showing you it's been marked in this case is exhibit number 380. This will just be brief, but can you tell me what that is?
That's a copy of my statement of qualifications.
And does that list your training and education in this field, making you qualified to comment on some of the matters you're going to comment on today?
Yes.
I'll move 380 into evidence.
Thank you so much, Mark, for gifting memberships. We appreciate you.
Objection.
Thank you. It is received.
Those masks make everybody breathe so heavy.
At times over the past year, since July of this year, have you been asked to become involved at various times into an investigation into a homicide that occurred over in Windsor involving some people with the names of Bart Halderson, Krista Halderson, Chandler Halderson?
Yes.
And have you produced numerous reports related to your analysis of separate items that have been submitted to you over that course of time?
Yes, I believe 4 reports.
Can I briefly ask you who makes the decision to submit items to the crime lab?
That's up to the agency to submit, but then we also have submission guidelines in place on certain types of cases of how many items we'll allow upon submission. But as long as we have a meeting with the agency, we may allow more.
Sure. In general, in most cases, what is that limit of items that can be submitted?
10 for homicides?
And was that far exceeded in this case?
Yes.
Okay. And you were in fact the one who had to do with the testing?
Yes.
Okay. I'm showing you what's been marked in this case. I'm going to show you all 4 exhibits at once, then we'll go through them. Can you tell us what exhibit number 383 is, just briefly? And you might want to turn one page in.
This is my report dated July 29th. It has my signature on it.
And does that appear to be a true and accurate copy of your report?
Yes.
All right. I'll show you what's been marked in this case as exhibit number 417. Same question, turn a page in and let me know what that is.
This is my report dated September 1st, 2021.
And does that appear to be a true and accurate report or a copy of the report on that date?
It appears to be.
Okay, I'll take that one from you. Showing you what's been marked as exhibit number 418, same questions.
This is a report dated October 6th, 2021 that I authored.
And appear to be a true and accurate copy.
Yes.
And lastly, 560, same questions.
This appears to be a report that I authored dated November 8th, 2021.
True and accurate
Brenda.
copy.
Yes.
At this time, Judge, I'll move for 17, 18, 383, and 560 into evidence.
Any objection?
No objection.
They are all received.
And I'll move to publish.
You may publish.
Ms. Jones, in preparation for testifying today, in order to make this a more visually understandable experience for everyone, you understand that your report has been maybe cut apart and put into PowerPoints for everyone to see?
Yes.
And so we'll start with, you were asked to perform a report and you did write a report on July 29th, 2021. Was this your first report in this case?
Yes, it was.
Okay. And as I'm talking about each report, in fact, I'll just give you a copy and you can go ahead and just let us know if you're referencing that report, okay? And I see you brought some materials with you. If you need to reference, let us know that you need to refresh your recollection and we'll let you go ahead and do that. Just so there's a clear record, we'll just say that out loud, even though it might be a tad awkward or not normal. We'll go through this one somewhat slowly so everyone can understand maybe how these reports take form. But the first section of your report, we talk about items examined. So what did you examine here?
I examined a dried blood standard reportedly from Bart Halderson, an electric toothbrush head reportedly used by Krista Halderson, and then some samples reportedly of human remains, K1 through K6 of differing body parts, and then a buccal swab standard reportedly from Mitchell Halderson.
Okay. And I'm going to show you a couple of these items just so we're talking about the same thing. I'm going to show you what's been received into evidence already in this case. It's been labeled with the exhibit sticker 194 and it's labeled electric toothbrush head. We're not going to open it or anything, but do you see anything on there that indicates that item has been to the lab?
It has our yellow barcode label with the case number and the item number.
And the case number in this case is what?
M21-1575.
Okay. Does anybody have any
And-
objections? Well, it's too late. I've already done it. We're not going to sit here and listen to DNA stuff, you guys. I'm sorry. It is boring as watching paint dry. The point is that they found the DNA. They checked the DNA for everyone in the house. And of course, everything matched up. Thus why Chandler, more evidence against him. Now we're going to go on to the interesting stuff.
Would the state wish to proceed with some additional testimony from one of the case detectives?
Some pictures.
I think we'll go, ladies and gentlemen, without a break, but we'll be breaking a little bit earlier for the day as a result, if that's all right. Unless anybody needs a time or a moment, then we can go forward. Go right ahead.
I'm going to call for limited purpose Detective Sabrina Sims. HDMI over here.
These are outdoor photos they're going to look at. I don't know what she's got. She's like one of the main detectives on the whole case, you guys. They're bringing her back up again. Trialaholics. Hey, Deb.
Oh, no, turn back now to the H.
No. To turn it off until we're
turn it
ready.
off. Okay, I'm sorry.
Sorry, just didn't want it to see.
Okay.
Okay. All right. Good afternoon. Is your name still Sabrina Sims?
Still.
Yes, it is.
And you are one of the two case detectives in this case.
Yes, I am.
I want to talk to you a little bit about the different areas that were searched by police in connection to this case. Of course, one place that was searched was the Irwin Road address in Cottage Grove, Dane County, Wisconsin.
Yes.
And that was searched primarily because a human torso was found on the land.
That's correct.
Okay. And we've also talked with Greg Leatherberry and others, the 4595 Oak Springs Circle address in Windsor, Dane County, Wisconsin, was also searched by police.
Yes.
And that's primarily because of information that came out of seeing Chandler Halderson as being the person that was seen close to where the torso was. So you were looking for a crime scene.
That's correct.
Okay. I'm going to show you what has been marked as exhibits 459 through 465. If you would look at exhibits 459 through 465. And as a group, would you describe those exhibits as photographs of other locations searched by the Dane County Sheriff's Office?
Yes, I would.
I would move exhibits 459 through 465 into evidence at this time.
No objection.
They are received.
And I would ask to publish.
You may publish.
And I will take the HDMI now.
Attorney Raymond, is the podium in your way as far as sight lines to the witness?
No,
Oh,
it's fine
okay.
for me.
I couldn't tell from my angle. Thank you, Attorney Brown.
I think it's connected if it's turned, is it turned on?
Thank you.
Okay. Detective Sims, what does exhibit 459 show?
This is a drone image of the backyard of the Halderson home, overlooking the pond area directly behind the Halderson home.
And was this pond area searched?
Yes, it was.
Tell me about that. How did the Dane County Sheriff's Office search the pond?
It was definitely done with a lot of thought, with cooperation with the pond owner, all of the residents that lived on the pond. We had to get consent from all of them. Obviously, we've taken in consideration the wildlife and fish around the pond. We didn't want to disturb that as part of our decision-making. We searched the pond because of the proximity to the residents, being directly behind the residents. At the point the decision was made to search the pond, we were still looking for numerous items of evidence. If you can see in this photograph, I guess it would be on the right side, that is our dive team truck. We had our dive team assist in part of this search. So they obviously got into the water. They also had difficulty in the search because, as you can see, there's numerous weeds growing in the pond. So as the search started, some of the divers who are Dane County deputy sheriffs, they just were struggling with the environment and the weeds below the water. So a decision was made in cooperation again with the pond owner. And we also used Dane County Parks to assist in cutting weeds out of the park or out of the pond. So we brought in a weed cutter and methodically so that the divers would have an easier time searching the area to try to get to the bottom of the pond.
Did the team also search all the weeds that they cut to make sure no items of evidence were missed?
Yes, we did. That happened over 2 days, actually. The weeds were cut, taken on a conveyor belt, transported to the Dane County Law Enforcement Training Center, laid out in different batches, and searched by hand, and also a cadaver canine ran around the different piles of weeds as well.
Showing you what's been marked as exhibit 460. Is this just a different view of the pond?
Yes, it is.
And that's after some of the water has been drained. Is that fair?
That is fair to say. I should backtrack. The decision initially was to drain the pond to assist the divers. As is with any plan, sometimes that changes because as the water was decreasing in the pond, it actually made it more difficult for the divers. So at that point, the decision was made to cut the weeds.
Being more did it become more difficult because of the mud?
Yes,
the
the
weeds.
bottom, from what I was told, it was, there was a lot of silt at the bottom. The divers were kind of getting stuck, you know, as they were trying to get to the bottom, feeling by hand, but also, you know, with their feet.
And at the end of the day, was anything of evidentiary value located in the pond?
No, it was not.
Now I'm going to show you what's already been received as Exhibit 532. This is the Snapchat that the girlfriend Kat Melander took of Chandler area location. Did that lead to a search?
Yes, it did.
And that's the search that we've heard previously about where the legs of Mrs. Halderson were collected.
Yes.
We heard Greg Leatherberry yesterday talk about how the trash can tested positive for blood. Based on that information, what, if any, searches did the Dane County Sheriff's Office perform?
So we actually had talked about the red staining that Deputy Leatherberry observed on the garbage can, and his plan was to test that staining, and if it tested positive for blood and then human blood, we had made the decision that we were going to search a landfill. So we had a detective, I guess basically follow from where the truck picked up the trash at the Windsor residence, where that trash went, which ultimately was a transfer point, and it ended up in a landfill in Jefferson County, a waste management landfill. We also had confirmation that the trash went out on Monday, July 5th, 2021. And we had that information because we know the route, but also because of the surveillance video that we got from 111 Oak Springs. So we actually saw the garbage can and the recycle bin wheeled to the curb by Chandler. So based on the time frame from when the garbage went out to when we had started our investigation, we felt that it was necessary to search the landfill, knowing that that task would be, you know, very, very challenging. Something that, in my experience as a detective, or actually as the Sheriff's Office for Dane County, we have never done.
And I'm showing you Exhibit 461. What in the world is Exhibit 461?
Again, this is a drone image of the landfill. It's the Deer Track landfill in Watertown, which is in Jefferson County. This was taken as part of our like recon of the area. This was the area that Detective Meyerhofer had worked with the landfill management and determined that this was the cell area where we believed that the trash from the Halderson residents ended up.
Okay. And Exhibit 462, how would you describe Exhibit 462?
Again, this is just a drone image overlooking the area. You can see, I guess, to the far left of the screen, that is Interstate 94.
No, this is the pond behind his family's house, the parents' home.
And then kind of directly in the center of the screen towards the bottom is the specific cell or trash area we were going to be searching.
Exhibit 463. Could you please describe that for the
Yes,
jury?
463 is, I guess, as the process was going, this was taken, as you can see, there's plastic bags all over the place. There's wood. There's actually an individual standing pretty much in the center, upper center of the picture. He's wearing a yellow shirt and blue hard hat. He's standing basically in the cell area that they searched.
Wow.
The cell area, if I remember right,
It's huge.
I want to say it was 50 feet wide by 50 feet. 50 feet wide by 50 feet, and then like 10 feet deep. It was a total of 20,000 cubic feet that they searched.
And was it basically they went piece by piece?
They did. Again, that was, meetings we had to logistically plan how to do that safely because of the environment you're going in, the safety equipment that was needed. We actually, deputies that worked at the landfill for the 2 weeks that we did that had to take an OSHA training before participating in the search. And that was done with, the best safety measures we could over the time period that we were there.
Exhibit 464.
464 is yet another image of the individual standing, more just for reference to determine like how deep the trash is. The individual standing there, he's approximately 5'9". So just for like a reference point of what you're looking at. Again, he's standing in the center of compacted trash. The trash is compacted numerous times. It's smashed from the time it gets taken from the curb in the truck to the transfer point. It's actually ran over with, it's almost like spikes smashed down to try to obviously tear it apart and smash it, which made it very difficult to search. You can see the torn pieces of paper, plastic, items you really can't even make out within this image.
And then finally, exhibit 465,
This
another
is just,
picture of the dump search.
yes, this is just a close-up, again, just trying to show the depth of the trash that was being searched.
Now, did the search team come across any items of blood?
They did.
And did those end up being of any evidentiary value?
No, they did not. I should say that we were working in conjunction with the medical examiner's office and the forensic anthropologist, Dr. Christina Figueroa Soto, as well, in case we did come across anything. There were some bones that were found, none of those determined to be human bone. There was medical waste, bags of blood, stuff like that.
And about how many people were involved in that search?
I would say each day, it was approximately 10 to 12 people for a total of 10 days, that same amount each day.
Okay, and did you receive any tips from citizens throughout this investigation?
We did.
About how many of those would you estimate?
I would say between 30 and 40.
And was each tip followed up on?
Yes.
Did one of those tips result in a search of the Lord of Love Church?
Yes,
in
it did.
Windsor, Wisconsin?
Yes, it did.
How long and can you just tell me about that property and how it was searched?
Yep, so that tip came in, I want to say 2 weeks into the investigation. I want to say it was July 17th that we actually searched that area. The church itself is located south of the Halderson home, so in close distance-wise to the home. So we put a search team together based on the information from the tipster that there was an odor coming from some of the grass property that was behind the church. There's also like a walkway around that area. Ultimately, it was determined there was actually some sewer work being done in that area. We did search it with a large search team, a cadaver canine, and ultimately located nothing.
Did you guys also search the town of Burke Park, which is right outside of Sun Prairie, Wisconsin?
Yes, we did.
Why did you search that area?
Throughout the investigation, we were talking to numerous witnesses, people that knew Chandler Halderson. We had received information from some of the people that we interviewed that it was a park that Mr. Halderson or Chandler would frequent or had been to in the past. It's a very rural park. There's a waterway there. There's a bridge and a large field you can walk across. So we thought, using our resources on the same day of the Lord of Love search, we would search the town of Burke Park to determine if we could find any evidence there, and ultimately we did not.
Was the Pine Island Wildlife Area in Portage, Wisconsin searched?
Yes, it was.
Why was that area searched?
At that point in the investigation, when we decided to search that area, we had received cell phone records from Chandler's cell phone. So this had been weeks into the investigation. We worked with an analyst who mapped his cell phone records, and we had determined that there was a trip to the Pine Island Wildlife Area, which is in Columbia County, which is an area that is along the Wisconsin River. Chandler was out there late in the evening, between 10:30 and 11 at night. His cell phone was in that area for several minutes, and we just thought, based on all of the information we had so far in our investigation, how we had found at this point Krista Halderson's legs at the Wisconsin River in Roxbury, we thought we needed to search that area up in
Wow.
Portage as well.
And does that area run along the Wisconsin River?
It does.
And did you have your dive team out to that location?
Yes, we did. We actually conducted a search over a couple of different days. Just the landscape overall is challenging. There's bogs and different waterways. The area in which we searched, it was right along Levee Road, which is a levee that butts up to the Wisconsin River. That river itself, the water level fluctuates quite a bit, and it also has a strong current. So we had searched it on foot with search teams one day, and ultimately deciding that we would try and put our divers into the water after a cadaver canine had alerted along the banks of one of the search areas. The Dane County Sheriff's Office dive team did go out there one day, also with the DNR and Columbia County Sheriff's Office. And one of our divers did get in the water, and immediately upon getting in the water, it was realized that it was very dangerous. It was something that our dive team had not done before in the Wisconsin River. Due to the current and just how strong the current was, it was such a dangerous situation that we basically pulled him back into the boat and did no more searching there.
But you mentioned a cadaver dog did alert along the shore.
Yes, we utilized a couple of different officers that have cadaver canines that are employed at the City of Madison Police Department, and we did a mutual aid request for their assistance.
I wonder if any of their remains were in the water.
No further questions at this time.
Cross-examination.
No, thank you.
No, thank you. All right, I'm going to put up what I meant to do yesterday, and I forgot about it. Forgot all about it. So we're going to play it because during the middle of the trial, Chandler Halderson got COVID. Where did I have it at? Can you imagine being a jury and being informed that someone in the trial, very key in the trial, now has COVID? So guess what? We're delayed.
Good morning, folks. As you can tell, it's a little bit different in here today. Someone essential to the proceedings has tested positive, and as a result, everyone who was in the well of the courtroom on both sides have taken steps to quarantine under all the guidance provided by the CDC and our local authorities. I do not believe that you in any way would have been subject to exposure, but I do have to suspend our proceedings for a period of time because we cannot do any of our work through remote access through Zoom or any other means. It just is not feasible whatsoever. And as a result, it is necessary to engage in a pause in this trial. Now, I learned of this, but couldn't do anything last night to contact people to say this is happening, because I needed to see you this morning in order to give you directions about what to do and to talk to you about continuing in your responsibilities. Otherwise, I would have been happy to not have you have to come in this morning, since I knew we weren't going to be proceeding with evidence today. But I have prepared an order that I'll be giving you in writing and reading in a few minutes, as far as what our intent is and what your obligations are. And I can let you know that there are two things that we're asking you to do, and it's one of them at least is mentioned in the order. We'll need to know that we have the way you want to be contacted. So if we can, before you go, confirm or get confirmation of phone numbers and emails, if you like email contacts, so that we can let you know precisely when we will be asking you to come back and resume. Secondly, I do have available through the county rapid in-home tests that you can take with you.
I guess that I'm sure the media let us know that he was the one that had COVID, the defendant. But I would assume they just can't tell the jury who it is that has it. I guess. So yeah, he got too lazy? You think so, or he got interrupted? Because remember that lady? There was a lady that saw him out there and thought he seemed really strange, and he might have gotten scared because he saw people out in the area. I don't know. Now I'm saying a lot because of that lady. Hope I don't do that all the time. Do I do that all the time? See? All right. So let's move over now to the Darrell Brooks trial. I'll have to do a share screen for that one. And where we left off yesterday was the area where Sue had just given her closing statements, and it was the very end of it, and then they went into a break, and they're now coming out of the break eventually. All right. Casey, how you doing, honey? Oh, wait, I might have it on. No, I'm not muted. It's not muted. They just haven't turned the sound in the courtroom on yet. I guess they brought him back in, because remember when she was giving her closing, he was put in the other courtroom because he was being such an idiot. I wonder how many. Did anybody count how many times he got put in the other courtroom? Is it on our list, our sheet, our tally that that person sent me? Remember the person who sent me the Excel spreadsheet of all the things that were done and said in the trial? I think him going to the other courtroom was on the list. I'd have to go over here and look it up. I think I've got it over here. Hopefully I saved it on here. There it is. Oh, it's too small. It's hard to read. Holding in contempt. How many times he said hold me in contempt?
That Mr. Brooks is now
We'll look at it
present
after this.
in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
Oh, thank you, Lenny.
To address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Yes, he did. You guys, she gave him a written notice about SMJ, subject matter jurisdiction, a long time ago in the trial. We saw her do it. It was on tape. It's on the court records. And the only reason he's doing this now is because he knows it's at the end and his time away from his real jail life is about to come to an end.
Mr. Brooks, I'm going to ask you one more time. Are you
Hey,
prepared
Sharon.
with your closing argument? I'm going to have the jury brought out. There's no
I'm
other
in-
legal arguments I
I'm
need to address
informed
from
of-
you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record. That is done electronically with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Jeez.
Is it proven subject matter jurisdiction?
Oh my gosh.
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction. And I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law.
Oh, that's right, Patty. He did tear it up right in
And
front
it
of her,
does
didn't he?
not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you
Please
aware of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor?
What a child.
Or is that a
39 years
tacit
old.
agreement that you
40.
don't have to answer any
Just-
questions as a public servant?
All rise.
So that is a tacit agreement.
Now he knows how to pronounce tacit.
Record to reflect the jury is coming out.
Oh, that's right, Lenny. He did accept it for value and return for value. He's an idiot.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
Too bad.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they
Truth.
have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you
They
inform
will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the-
to the,
It's true. They have the power.
all right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
Laura's got baby bottles put up. He is a child, you guys. He's 40 years old, I think, at this point during this. Unbelievable. Thank you so much, Miss Casey, for your gifted membership. Who got it? I hope you feel better. He got his information from the law library, Patty said. Hey, CK.
Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time. And then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice. So you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of
the
those that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Oh
make
my
that correct.
gosh.
Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are you
trying to
telling me,
give.
sir, that
It's
you are
not trying
going
to
to
give.
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the, you just said on the record that they have the power for,
Sir, I direct your
you
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I just
disregard
told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Vjerkas says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
The
I just want them
Sir,
merely to be
you
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether
they should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that you
power that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's
because
not what
there
I'm
is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely inform them of the power that they have. That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification.
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If you
Your Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say
then
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
the record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding
the
a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
Or
how
you've
did
interrupted me
I have why did I
repeatedly.
have to sit here for
Get
that
him,
where I
Joe.
could have just went to my cell and had it delivered?
Oh, what? This ain't Uber.
We had this
Mr.
at the end
Brooks.
of last night before you called
I'm
recess.
not going to
We
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court.
Here we
You
go with
can
this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify.
Would you
any
like,
law,
if you would like,
but then I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No,
because the more
you can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Oh my
Sir,
word.
I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 39 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture or conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
He's run out of things to
Are you
excuse
willing
this.
to make a closing argument, sir?
He's
that
gonna go
does
back to,
not
I don't
reference
understand.
Jury nullification.
I'm going to inform the jury of their power.
Oh my goodness.
Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did
you,
you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
go
Oh
ahead.
my gosh.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one.
His friend
So
is
how
back
is me
behind him.
merely informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkas, 163 Wisconsin 2nd at
Well, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases, Your
case from
Honor.
1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presenting arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
That
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently,
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Vehemently.
Your objection is noted for the record. But
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about
How I
a
want it
closing
to.
argument.
Oh my gosh.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your appeal
confused.
to
I'm confused, Your
to
Honor,
a court of
because
appeals, not this court.
no, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
That's a baseless argument, sir.
You guys look at look what Barbara said. She said, "You think his mom ever looked at him and said, 'Look at my little future brain surgeon. Now put those bugs down and give us a hug.'"
I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this
I
rule.
haven't argued it. I said that I wanted to inform the jury of their power. I never once said, I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why not?
jury
Why can't they be
nullification,
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
Then
upon
I make a
how I've
oral,
outlined that to
motion
date.
for
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under what
argument.
lawful law can you,
And then if you continue to
under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative? And I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
allow him to make his closing arguments. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require
The patience of
effort
Job.
for the court to allow this to allow Mr. Brooks to try and proceed. But I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
She's so right. She is so right.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
He's so stupid. I just don't want to
Your
go
objection
forward.
is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
Oh, you're a fool. Hey, Kimberly, you
I
can
decline to reconsider.
email it to me, Kimberly.
I reject
take
that
a look.
ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction
Denied.
under,
The jury
based
is
on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
He's just trying to stall. He doesn't care what he said, if what he says makes any sense. He's just going to do whatever he can to get thrown out, stall the time, because he knows that he's at the last hour of everything. Military court. Exactly, Kimmy. Even if she did give him what he wanted, he would turn around and find something else to argue about. Then it would fall back on that I don't understand.
Thank you, everyone. Please
Argument.
be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
He has the nerve.
Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth.
With an F.
You should be informed that you have the power to nullify any law that you don't agree with.
Objection, move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
Oh.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause.
Did you catch the long pause? Just make sure you caught the long pause. I'm just a little emotional.
It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. There's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do. You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make a model of 2010 Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The juror will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's
completely
information,
inaccurate,
it's
Your Honor.
There's an
information.
objection. Hold on.
Strike.
Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's complete misstatement.
Sustained.
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life.
Thank you, Jonathan.
Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord. Held them before their mom even did.
Oh, no, he didn't.
Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage?
Merry Christmas to you too,
How can
Jonathan.
you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why was someone with
Oh,
intent
my
to kill and
word.
rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle?
He was. He could have hit the brake.
Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played a exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school.
He don't even know. He doesn't even know that.
For my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss.
He can't even really break any tears on that one either, as much as he tries.
Having to navigate
Even though it's a lie.
everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't.
Does he actually think the jury cares what he feels like, or how he feels, or?
As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe.
Sue's writing her grocery list.
But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything.
I
You
gotta,
have the decision.
I gotta grab my tissue. Hang on, y'all.
You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Now he's gonna use his first his kids. Now he's gonna use Jesus.
That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb.
There's no way. There's no way.
This is how my family lives their life. This is how we was raised.
We all know where the family's at. His sister died of an overdose.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
I can't believe he said that.
And because I believe, I trust him with my life.
His conscience is clear. How did they hold back in the courtroom after he said that?
Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power.
The tinted
Don't let
windows.
the theatrics take away your power. Each and every one of you has a decision. Do what's right. Make the right decision. It's hard to think about. My younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much.
Well, you, of course, a lot smarter than you. I guess this stuff worked on all the women he hung out with.
I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you? I haven't read the rest of that letter yet. The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them.
Nah, you should see the chat.
Never has been, never will be. So before I close my statements, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. pray, and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a long lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. Took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir.
There's no letter.
Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand. All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Mic drop, but it was a pin drop.
Now, members of the jury, The duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty.
Okay, I'm
You
not
will
gonna.
not be swayed by sympathy, prejudice, or passion.
Do y'all want to listen to her read the jury instructions? That wasn't opera mic drop. That was, except she used a pen instead of a microphone. And I love, and I think she probably did this on purpose, because she's an attorney. She knows how to jab, right? She knows how to get people where it hurts. Her last statement to him was about his kids, telling him he needed to do something. You know that he cannot forget her saying that. That drives him insane probably every time. I bet he thinks about it all the time. There was no letter. There was no letter. He's so lying. Okay, so Laura wants to know about what happened with the Reddit post. The Reddit post, after they investigated it, which didn't take long, they realized that the person that wrote it had been on Reddit for quite some time. That was the actual person that went in and edited it and took it down and said, I was kidding, blah, blah, blah. They found the right person. It wasn't a juror. Hey, Warrior Woman from Sydney, Australia. Welcome back. It was an excellent rebuttal. So I want to go back into the chat and see what some of you guys are saying. Because I had a few things start. First of all, I want to thank you, Laura, for being a member for 2 months. And I want to thank JCP and Mark for gifting 5 memberships each. You guys are awesome. And KC for gifting me a membership. And Jonathan for his super chat. Thank you so much. And John Bubba, you type something in the chat. You always do this to me. You type good stuff in the chat, something really funny, and it's the worst time for me to put it up. And I know you don't do it on purpose, but I was like, oh. John Bubba said when Brooks first started his speech, he goes, oh God, it finally happened. I rolled my eyes and they got stuck. Help. Another thing that I wanted to bring up was Janelle. Hey there, girl. She said, from Waukesha, she said, I wish they would have asked how the vehicle stopped in the driveway, how he slowed down to turn. Such a liar. And you know what? That's a good point. They didn't have to. They didn't need to. But if they wanted to, that would have been great for them to say that. And how did you get the vehicle to come to a complete stop? He would have said, number one, I don't consent to being called that name. And I didn't stop the vehicle. Yes, the right decision was made, Miss Janice. Hey, Anita. Wonder if the jury is even looking at him. It would be creepy to have him looking back at you. Tim, I was thinking about that too. If you were a juror, would you even be looking at him when he was giving that speech? It's so disrespectful to everyone involved. And I know you're there to be the juror, but I don't think I could have looked at him. I probably would have looked at the judge or the prosecutors the whole time. I don't think I could have looked at him. Would you guys would have wanted to do it? And also Coffee Cake, the documentary. Okay, here's what I think. Now, we know there was just that documentary that the WWE wrestler did, right? Because Jackson was he was the hero of Jackson's. That just came out. It's on Peacock and it's on the WWE network. It just came out this past week. But I haven't watched it yet. Have y'all watched it? Is it I'm sure it's tearjerker. But I really think if they're going to do a documentary on this tragedy, like a big one, it's going to be very classy. It's going to be done well. They're not going to let Brooks speak in it, have anything to say. It's just, I just can't see that. I mean, not to say that there's not going to be some smaller ones done where they're going to, it's all about him, but I just can't. I just see a big station doing a big documentary on the tragedy itself, the victims, the town, the jurors, the prosecution, the judge. I mean, they could talk to, there's so many other people to talk to. You don't need to talk to him. And I just don't see him doing that. That's just the way I look at it. And Janice, thank you, honey. Glad you made it to a live. It's good to see you. You're so kind. So let me go back over here in the chat and see what y'all think about if you were looking at him, would you have been able to look? You're all, a lot of y'all are saying no. Is that to my thing? Are we doing the verdict video? Yeah, we're going to do that. We'll do that in this next week or the following. Cher. Oh, Cher's got a good recipe she'll send y'all. You guys. That's too much. It's just too much. I can't. It was funny because literally during his acceptance speech is what I like to call it. Frankie looked at me like, you gotta take me outside. My big 100-pound dog. He's like, yeah, this is making me sick. I need to go outside. And he did. He had to go outside and take care of business. So I was like, I missed some of it, but I don't blame Frankie. They're tired of hearing it too. You know, him and Bruiser, they're done. They're tired of it. They're tired of Brooks. Hey, Abby. John said a documentary about the law enforcement investigation, manhunt, behind the scenes of the courthouse, and the madness of the hospitals. Yeah, I agree. That's a good idea, John. I agree with that completely. And speaking of which, if you guys haven't seen the piece I put together on the manhunt, it was what I had got from Waukesha PD. Go back and look for that. It's on my channel under the Waukesha Christmas Parade Attack playlist. Go back and watch that if you haven't. It's really good. I mean, all I did was put videos together, but it really takes you there, and it takes you to when they pulled him down. There's actually 2 connected to it, I think. Word salad. Is that what it is? A word salad? It was an acceptance speech, Kimmy. Oh, thank you very much. Frankie and Bruiser know that Darrell is bad news. They can sense it. Yes, my dogs know. You know what the saying is, if your dog doesn't like somebody. There's a saying there. It's true. The geriatric gangster Reddit post heard around the world. Hey, hippie chick, welcome back. Well, I'm going to go ahead and close it out for now, you guys. We've been on for a little over 2 hours, and there's only so much of him we can take per night, right? At least me, anyway. I want to thank you all for being here this evening. I have a family member I have to take care of who has to go for some surgery this week. I'm going to do my best to be here back on a live tomorrow, but I do have some other stuff I'm dropping in the meantime. So I hope to see you guys very, very soon, definitely before Christmas. Y'all be safe, be good. Santa's watching. At Carrie, I think my dog called your dogs. I saw a number and didn't recognize on the bill. You saw a number you didn't recognize on your phone bill. Dang it. Why do y'all have to keep writing such good stuff? See, I never get to log out and say bye and just call it a day. I always have to keep going. Thank you, Ward. Thank you, guys. I appreciate that. Yes, please send up prayers. Please send up prayers for my sister. It's a surgery, but it's still the fact of somebody going into surgery makes me nervous. So, can I show a picture of my dogs? I actually had one. I have them on my community thing, but I will one day. I'll pull them up again. I don't have them on any right now to show you guys because I have to take everything off my computer because my computer has so much junk on it from the videos that I literally have no space on my PC. I've got to do something about that over the holidays. Thank you all for being here. Love you guys. Have a blessed evening, and I will talk to you very, very soon. Good night.